Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
The wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican for you, verbal fucking.
Literally not true.
I didn't ask you to interrupt me.
Oh, for Trump's sake.
Is that correct?
Wow. Oh, there we are. There we are. Yeah, I know I forgot to click one button. I'm like, something's missing, and it's not here, it's over there. So. Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Please, please take a seat, take a seat. We're setting up the chairs right now, so help yourself. Get yourself comfortable. Is it too early to just kick it right into the rap?
The pickles and you want some. Don't interrupt cause I don't want your lame objection. From that t-shirt to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells all rise and pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe because there will never be another creator like me.
Correct?
Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral. They the good not to share. Came in late, check the thumbnails. You'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal.
Because he's the guy.
I object.
All right, that's all. Nice. Ashley, we thought of the same thing. All right, good morning, good morning, good morning. We're still working on the music. It's a work in progress, so thought we'd share that this morning. Good morning. We're going to, first of all, kick things off with
Alex stole it as well.
With Golden Girl. Good morning, Golden Girl. Congratulations.
Lunch, Judge?
Soon, I promise, soon. We're going to break for lunch in a little while. But first, Golden Girl, congratulations. You're first in chat this morning. You know the drill. You've won before. It's been a while, but you've won before. At least we have a record for you. So if it's a false conviction, let us know. We'll get it overturned. But yeah, repeat offender, I guess, now. The internet is all yours. Please make sure you keep it up and running for the rest of us.
This is not Burger King. People do not get to have it their way.
How does he do that?
Let's see. That's it. You won, Golden Girl. Congratulations. Get yourself your certificate. Include it on your resume. It makes a great cover sheet. Everyone's impressed with those sort of things. All right, we are going to have some birthday wishes coming in just a minute. So hopefully you've got all that information in. Thank you, Sharon, for heading that up.
The zombie apocalypse may be upon us.
What does your family think of this? Everybody loves it. Everybody except Mrs. R.A. She is not a fan of rap. Like zero parts of her like rap. And she looks at me and smiles like I married the goofy guy. That's her thought when she hears that song. It's like, yeah, but he's got a cool rap song. She's not convinced at all. Is the bathroom finished? DSN, don't rub it in. Don't rub it in. We are so close. Last night I did the flooring. I don't know. Has anyone done they call it LVP flooring before? It's a snap together wood. They call it luxury vinyl. I don't remember. It's really nice. It makes a great floor. I love the look, love the feel. The quality is top notch. It's waterproof. It's great. You buy it in packs, like big, huge, heavy. They weigh like 60 pounds each. I need 2 more pieces, which means I need to buy a huge other pack to finish it. But after building it halfway and then realizing I was doing it wrong and taking it all apart and rebuilding it, it's looking really good now.
Because he's the guy.
Really good. Let's see. Other than that, so toilet and shower today. Those are going in. Also doing the baseboard first, and that's all. But so we're not done. But the guests arrive in the Airbnb in 2 days. So I have
How does he do that?
All right. Let's see. How is Buffer already not working today? Buffer's not working? Buffer started working. Here we go. Let's see. Levi born yesterday. Emily, mom to Levi, had a birthday on the 28th. So we'll sing to Levi and Emily. Tash and Andrew are all celebrating their special day with us. That means we have 4 people to sing to. Levi, Emily, Tash, and Andrew. Is it buffering on your end? Should be working on my end. Yes, we have our first guest, and I think Mr. Beast's, Mr. Beast is flying in a crew from, I think, mostly California, West Coast, and there's a big project they're working on, so he's flying in people, and he's flying in like husband and wife teams, because he does that, okay? He'll fly in a family to work on his project. And so I think their broker called us and said we'd like to book it for 3 months, so we're trying to line that up, but we'll see. See if it goes through. Let's see. That should start in just a couple. That starts in like a week or 2, if they do it. All right. No new trial for George Kelly in Arizona. That's right. Birthdays. We're in the middle of the birthdays. Don't let me forget. Please join with me as we celebrate the birthdays for Levi, Emily, Tash, and Andrew, all in one verse this time, I think, which will be great. Because we don't have much time. We have like 5 minutes before court starts. So join with me in singing the birthday song. This is not me. This is not a solo. Okay, if you think that I love listening to this song, you're doing it wrong. You need to join in and sing with us. So please raise your voices with me in celebrating these wonderful people on this special occasion. Let's warm up all together. La 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 la. There we go. Okay, dancers at the ready, stretched, costumes look good. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Levi, Emily, Tash, and Andrew. Happy birthday to you. To those who are celebrating their birthdays today, first of all, enjoy the dancing. But congratulations on your special day. It's wonderful. It's wonderful that you're here with us. It's wonderful we get to celebrate with you. There are a million people who would like to celebrate with you, and probably a million places you could celebrate. But you've chosen to be here with us, and that is wonderful too. That's like 7 wonderfuls. So it's going to be a great day. You thought I was going to say wonderful again, but it's going to be a great day. Happy birthday to y'all. Make sure you get your free pancakes at Denny's. I had pancakes this morning, courtesy of my son. He made them for me. They were delicious. Thank you. Highly recommend them. All right. Happy birthday, dancers. We're going to do a fade out. And remember the jazz hands. 1, 2, 1, 2, 3, and boom. There we go. Beautiful. It looks good. All right. Court should be beginning soon-ish. Where we are in this trial and what we thought was the Airbnb Gone Wild trial, which really ended up being a drug and gang awareness trial, or I guess rapid gang awareness trial is what we're I guess we need to recall this, but we are at the final day. The final day of testimony in this trial, as the state has arrested the first defendant, as we do have two defendants being tried side by side. The first defendant has rested as well without providing a defense. He did not testify, and he's not providing a defense. The second defendant, Mr. Pritchett, has said he wants to have a defense. Yes, Brandy hit 20K yesterday. That is awesome. That is awesome. I saw her tweet. She's like, she was 10 away when she tweeted. I'm like, oh, this is so good. Big congrats to Brandy. Brandy is following the Karen Reed trial. If you don't know what the Karen Reed trial is, you're definitely not on Twitter. I can tell you that. I've never seen a trial with such polarized sides at the beginning of the trial. It really, the battle lines have been drawn, and it's going to be a spicy trial. Assuming it goes all the way through. I don't know. But big congratulations to Brandy. She's worked really hard to get there, and she's done some amazing work. And it shows. I mean, she's been a guest on Law and Crime. I mean, that just tells you where she's at. Let's see. All right. We're going to. Okay, I'm trying to keep up track of where my texts are on. It was a late night working on the restroom, on the bathroom. So I'm going to try not to sleep today. Well, the accused bring in a surprise witness. We did a poll yesterday, Sherry, because he has a friend. I'm guessing. I mean, don't hold me to this, but I'm guessing it's a gang buddy. I don't know how else to say this. And the odds are, I mean, what happens if this guy gets asked if he's in a gang on the stand? Do they lie about it? Is there like an honor thing where you claim your gang and you don't ever deny it? But he puts his friend on the stand if he's in the same gang, and he gets asked, "Are you a member of the gang?" Is he going to say no? And if he asks, do you know if so-and-so is a member of the gang, and is he going to say yes? I think there's a downside. We're not sure if he's going to show up. I think about 80% of us, I think it was, said he wasn't going to show up. So my entire YouTube recommendation has been taken over by channels covering Karen Reed. It's a big trial. It's a big trial. We're not following that one, but it just started yesterday. A super long jury selection, very long. Yeah, it's gonna be a good trial. Thanks, Rebecca. You should hide it more often. She gets in trouble. All right. Maybe he can impeach the gang expert using his witness. That was funny when Mr. Pritchett, or the accused as we're calling him, which, by the way, when we talk about the accused, he's been called the accused 89 times so far in this trial. 89 times he's been referred to as the accused. And at the beginning of the trial, he started out not just pro se, which is acting as in your own defense, but he also started out as sov sit, which means I'm a sovereign citizen and the court doesn't have any authority or jurisdiction over me. And it got pretty crazy at the beginning. He wouldn't even sit down until he'd been, his questions had been answered about the right the court has, and it was crazy. It was really crazy. Finally, judge got him to sit down, and once he sat down, he became a new man. He just went straight pro se, and he learned. He learned mostly by copying the defense team that went right before him. He just mirrored them, but he's learned a little bit. Yesterday, he went back to pro se and sov sit. And it's sort of an interesting little mix of the two. But I purposely do all of my toddler YouTube stuff on my husband's YouTube account just to mess up his feed. That's awesome. All right. Anyway, court is going to be starting here soon with Judge McBurney. Anytime this morning would be great. Judge gave him a bit of advice, shaggy defense. Yeah, judge told him, instead of saying they haven't provided any evidence, maybe focus on the fact that it wasn't me. Oh my goodness. And in my home state here, this was sad. Sad day in Charlotte. 3 U.S. deputy marshals and 1 local police officer died. Total of 8 shot. Just a crazy, crazy situation. I don't know the details of how it started, but ended up in a SWAT type situation with officers pinned down getting shot at. And there's video all over the place of that, and it's really sad. Okay, we're probably waiting for witnesses. One in particular. Okay. They were serving a warrant. Yeah, it's bad. Let's see, anything else that we need to go over this morning? Court-wise, we talked about George Kelly finally being free completely and the charges being dropped or dismissed. Brandy hit 20K. That's huge. It's a cork day for sure. I think that's all. I think that's everything. I know I'm missing something, but it's just not coming to me. All right. If you guys, can you explain SovCit? Abby, SovCit is a sort of like our short version of sovereign citizen, where a sovereign citizen believes that they are sort of their own king or queen in their own little world, and that any interaction, especially with any government entity, is a interaction with an outside entity, and only those actions which the sovereign citizen authorizes are valid. So, being arrested, you don't have their permission to arrest them, and so that would be an unlawful arrest because you don't own me. I am my own person. I'm my own man, and you have no ownership over me. And they typically also find various fault with the laws and terminology. They'll talk about Admiralty Court because of the flag with a fringe on it, and prove the jurisdiction, prove that the court has jurisdiction over this subject matter, being me, my own free man. And they set up the arguments as such that you cannot argue with them because they only accept their answer. And so it just spins your wheels. It wastes the court's time. And they set it up to say there's nothing you can do about it because I'm right. That's how they set it up. And it's really frustrating. It's often very repetitive because there isn't a lot of thought behind it. It's not the sort of thing where they're citing case law on a regular basis. Because if you go back and look at the cases of the people who claimed sovereign citizen rights, they pretty much lost almost every time. So that's about it. Darrell Brooks was sovereign citizen, also pro se. You rarely, I think if ever, will find an attorney. I don't think I've seen a single one. Find an attorney who will put on a sovereign citizen defense for you. So they do go sort of hand in hand. Attorneys having sworn an oath and things like that as officers of the court, the attorneys respect the legal system, and the sovereign citizen arguments don't. And so an attorney can't really put up that defense and still maintain their license to practice law. Okay. Still nothing from court. We'll see what happens. It's a slow day. Today we don't have Chad Daybell. No Chad Daybell today, right, Ashley? Which is sort of sad for you guys over there on the Top Mark channel. Sounds good. the logic of pro se defendant is sort of funny because they oftentimes will seek the protections that are afforded them in the Constitution, while at the same time denying the obligations that fall upon them as a citizen. And it's just crazy. I think the trial will end today. We'll go to a verdict watch probably as early as about lunchtime, if anybody shows up for court, which so far, nada. All right. We have new yoga music. No. The rap is not yoga music. The juror with the conflict is tomorrow. Yes, Greta B. She's got her master's degree hooding ceremony that will take 2 to 3 hours. And the judge says we'll work around it if we have to. But I think ideally this goes to the jury and they deliberate quickly. It's going to be an all or nothing. I really don't think you're going to have a blended verdict where they say, well, we feel that, counts 1 through 15 were proven, 16 were like, no, it wasn't. 18 was, 17 was dropped, 19 wasn't, 20 was. It's not going to be piecemeal like that. I don't think. I think we'll get everything all at once. And it's most likely, I'm guessing guilty, even though there's a lot of circumstantial evidence. How much time? Jamie, I have not done the math for the charges because sometimes they can change a little bit, especially with lesser includeds, if those are included at the end. But maximum is a long time. You've got 20 years, firearms modifier, gang modifier. It's a lot. You've got 20 counts. Well, 19 now because one got thrown out. One was dropped yesterday. The judge said he would do a directed verdict on 1 count. And it had to do with the disfigurement of the individual who was hit in the nose. The state said in opening that he was permanently disfigured when he broke his nose. That witness, when he got on the stand, said he was bumped in the nose and it gave him a nosebleed. And the judge said, yeah, that didn't match up. Mother Beagle's member for 5 months. Thank you. He says, jury duty yesterday, saw emergency response in CLT while waiting. Let us go pretty fast. So sad for brave first responders. Thanks for distraction. Wow, jury duty yesterday. Congratulations. Thank you for serving on your civic duty there. To a model of scratches, permanent disfigurement. Okay, I see that, but he didn't even have a scratch. He just got a bloody nose. My son is coughing up a lung out in the hall. Thanks for sharing that. We've got nothing. Inspired by you, and I made an album for Brandy Churchwell Rap. 80s Music Man, I can't wait to hear it. Is it something that you can share or point us to? And we have a really good podcast coming on Thursday. 80s Music Man, is it something you own all the rights to? And if so, I mean, I'd like to listen to it, but I can't play it on the channel unless I'm 100% sure I don't get struck. So I need to know that you understand copyright law thoroughly and have all the rights if I try to play it. Or just maybe point it to me and I'll listen to it off air. Maybe send it on the burner phone or something. As far as the upcoming trials, let's see where we are. It's loading slowly. Adam Lil Banana Nusky. I see you went with your gang name. Love it. All right, we're on 4:30. It's the end of April. Can you believe that? It's actually the end of April. We have a Corey Richens hearing that's coming up soon, but no big trials other than obviously we've got Karen Reed going on, which we're not going to cover live. I may do some videos about different events or recapping things as I see it as it goes along, but I haven't committed to that yet, and that would not be live. That would probably be in the evenings. Delphi is not going to be covered because of the camera restrictions. Corey Richens, we've got Richard Walter Bradley Jr., which is the 4 gold digger murders coming up out of King, Washington. Owens via Eckert is all the way in at 6-1. Let's see. So I don't know. I've got to look at it. We'll see what's up. It's gonna be May. I wrote the lyrics. Had software do the singing. Brandy has yet to listen to it, so you don't want to share it till then. All right. I'll keep it under wraps until then. The jail cell guy. With Judge Simpson. He was supposed to be back in court on Monday, wasn't he? Was that yesterday? Did anybody see what happened with him? Did it go straight to a mental eval? Thought it was later this week. Sarah Boone's trial status is 6-7. June 7th is Sarah Boone's next hearing, so I'm not sure. That might be the trial date. I want grand reveal for Brandy first. Sounds good. Okay, so there's nothing coming from court. Adam Montgomery sentencing is coming up. Yes, Rodriguez, we watched the updates on the Arizona case live where the state elected not to refile the charges. They're or not to retry the case. They are dismissing the charges. There will be one more hearing coming up where the judge is going to determine if those charges are going to be dismissed with prejudice or not. If they're dismissed with prejudice, they cannot be refiled. If they're not dismissed with prejudice, then you might get a new prosecutor in who's like, hey, let's go back and try that case. That's low-hanging fruit. Let's go ahead and pick that one up. I think they will be dismissed with prejudice because the evidence has all been given back to Mr. Kelly, at least ordered to be returned. So he gets all his property back. I think it would be very difficult to retry this case. I think they should probably give him the freedom, if they're not going to try it, to say, no, we're not going to try it now or in the future. Got the painting done, yes. My daughter helped me. She did a great job. Status hearing for Boone is 6-7. So if everything is good at the status hearing, I think the soonest we'll see court is 2 weeks after that, right? Do they have a court date yet? You know what? We haven't checked. We haven't checked to see if she's written any letters lately. Do a quick search here. See what the updates are. No letters from Sarah Boone. Thanks for spoiling it for me, Amber. Just kidding. You just beat me to it. So the hearings on 6/7 don't have any dates after that yet. It's been quiet. Maybe she has a lawyer that's finally working with her the way she wants to be worked with, and that's why she's not writing letters. But it's going to be an awfully quiet day if court decides not to air the rest of this trial. Fix the delay on the buffer. Give me a second here. If I refresh this page, let me turn that down first. Okay, pop out chat there. Pause that so we don't get the audio. Go full screen. Okay, Amber, now, wait, not yet. There we go. So now try the buffer, see if that's any better. It'll only work for mods, by the way, so. Was that faster? That was pretty quick, right? My viewer that runs it was on delay. That's why. All right. Buffer. What word did I say?
Are we going to address subject matter jurisdiction?
The Q word. What was the Q word? Okay, here we go. Court's finally starting up.
Robbery as a capital offense.
Hang on.
Somebody just sent me a video of roaches fighting. I don't know.
Okay, so I need where's my? Here we go. Now we're up.
Ms. Rivers, are you ready? Yes. Great. Let's go on the record, please, in State versus Pritchett and Robinson. It is Tuesday, 9:15. We have our prosecutors. Mr. Robinson and his legal team are present, and Mr. Pritchett is here. A couple things just to knock them out quickly. Number one, regrettably, I have confirmed that the appellate courts of Georgia still view armed robbery as a capital offense, and it would be error for me to restrict closings to less than 2 hours. I will share with you all that it would be error by you to use 2 hours, but you can commit those errors and they wouldn't be a basis for appeal. So know that you have lots of time to share with the jury what you want to share with them. Second, I did some research on the question of lawyers in closing reading from transcripts of trial testimony. And it is allowed, but it is within the court's discretion. And there are even opinions that say, yes, while we've said it's okay, there's nothing wrong with a judge saying it's not okay. And because I have told the jurors several times that they will not get transcripts and that we don't have available for them any recordation of what the witnesses said, I think it would engender confusion, and we'd run the risk of jurors submitting a question during deliberations of, well, hey, could we have more of that video footage of juror testimony? And so my direction to you, Ms. Mignot, is to use your PowerPoint exactly as you have it, but don't press play on any of the embedded videos. You're free to share with the jury what you believe the testimony was, and even have bullet points of that on the slide as you described it. But I am electing to exercise my discretion in the direction of we don't actually play it back. Okay? Contrary to the Gwinnett judge's ruling, which is not an erroneous ruling either. I want to be clear, not in your defense, but in support of your creativity. There's a real old Supreme Court case, Brown versus State, here in Georgia from 1997, where a lawyer was reading from a transcript of trial testimony during closing argument, and they created a big fuss. And the court said, the court has the discretion to allow that because that's evidence. In the same way that if you wanted to play some of the Ring camera video, you could do that, the Ring camera video, during your closing. And I suspect we're going to see some video of something during, that's why we have the special DA screen in here. I view that replaying evidence as being fundamentally different from meaning testimony exhibits that were admitted, which the jurors can, during their deliberations, say, could we see the Ring camera video again? Could we watch Guns Up again? The answer is yes. The answer is no from me. Could we have a transcript of Officer Weems's testimony? No, you may not. And I don't want to create that confusion of, well, why are you saying no? Somehow Ms. Mignot was able to get us a recording of Latner's testimony or anyone else's. So I'm just explaining the basis for my ruling, but also encouraging you to continue to make that request, because my initial thought was that I'd find case law saying, of course, you cannot do that. And it's not. The case law is that it's the judge's discretion to manage what attorneys do and don't do during their closing arguments, with certain exceptions, no golden rule, that kind of stuff.
Okay, so Your Honor, I just wanted to state that the court is going to give an instruction to the jury that lawyer statements or anything the lawyer shows you, present to you, or try to, it's not what you're to use to decide. You're supposed to decide this case based on the evidence.
No, that's not. I do give an instruction, but it's not that. I will tell the jurors again, as I told them at the beginning, that they are free to be persuaded by what you say, about what you say the evidence is, about conflicts that you observe in the evidence, that they're free to be persuaded. That's your job right now, and you're going to do it real well. But ultimately, they will be deciding if there's a dispute about what color the sneakers were. Were they yellow or were they green? It may be more Mr. Pritchett who does this, could spend a long time talking about how they're yellow. But the fact that he says they're yellow doesn't make them yellow. They'll decide. So I will say something along those lines, but it won't be ignore Ms. Mignot or you can't be persuaded by her. If you think she's right when she says a witness said that, you need to disregard it because only you decide that. That's not the tenor or the content of what I share with them.
Right, but I think the court statement that the jurors would ask for, can you replay, that the court in its discretion could say, if it didn't come from there, we're not sending it back with you, then you can't replay it. It's no different from them saying, hey, can I see Ms. Mignot's PowerPoint slide again? You would say to them, no, even if I had a PowerPoint slide, which was a photograph of one of the witnesses on the stand. So I'm asking the court to consider that in the totality of the circumstance in terms of you being able to say to them, no, you cannot request that again.
It's going to be interesting. We'll see what
Just like you would be able to tell them, You can't request her PowerPoint slide. You cannot request her to replay something for you, or you cannot request a transcript of any statements because the court has already said that.
Okay.
So I would ask the court to reconsider its decision as it pertains to us being able to play, especially a small portion. Maybe we could show it to the court and see.
No, I had in mind, because you didn't say, and that was wise, you didn't say, yeah, and I've got 30 minutes of Riley's testimony and 9 hours of, it was snippets. So I was thinking about that as I was looking at this case law and pondering what I felt was the appropriate way to manage it. So I appreciate it. And it may be, if I'm fortunate enough to preside over a case you try a year from now, I will have evolved into the progressive Gwinnett approach. But for now, I am the regressive. They've heard the testimony, and that testimony won't be replayed through your PowerPoint or anyone else's. It may be presented to them through closing arguments, which you're free to do, but it won't be the actual press play, and they see Latner's mouth moving and the words coming out. I'm not quite ready for that, and I think it's not so much what I'm ready for. I think it's inconsistent with the concept and instructions that I've provided, that the jurors are to rely on their recollection, and there is not a way for them to have the witness testimony back when that's not a transcript of what was said, and there won't be a transcript, and we all agree with that, but it would be another medium through which they could have sort of in violation of continuing witness. And I guess part of my...
As they're working out this detail, they're still getting started today. We don't know if the witness
is infused with that notion of the continuing witness. It's not going back with the jury, to your point. They wouldn't say, could we play that slide again, meaning the content embedded in the slide. But I think it is of a family with the continuing witness. You wouldn't send a transcript of, if you had generated a transcript of the Kalish interview as part of the pretrial work you did, you wouldn't be able to send that back. And you know that, and you might try, but you would say, I get it. That's a fair ruling, Judge. And to me, this is of that family. No, it's not going back, but it is singling out certain parts of testimony and actually replaying it as if Sharon Latner's was in court again. And
it gives extra weight to portions
during your closing.
Testimony.
You don't get to say, wait, I want to just bring this witness in and say, hey, repeat that answer you gave. I understand why you want to do it, and you understand why I'm saying, let's use the slides, just don't press play on any of the slides.
So we would ask that the state not be allowed to replay any video footage based on that court's mindset and rationale and analysis, that
they don't like our rap.
Still shot of it, they can put up a picture of it, but they cannot replay any of the video because it would be tantamount to the same continuing witnesses rule, just like how we couldn't recall a witness. Replaying the video without any content would have the same effect. And we're asking that the state not be permitted to replay any of the video footage.
Okay, you're gonna go 0 for 2 on this one because the case law is very clear that videos, not a video recording of a statement, like a recording of an interrogation, but surveillance video, or if someone was at the scene and on her cell phone, there was a fight and that person recorded it, that the jury can review ad infinitum, and it's not a violation of continuing witness rule. And I don't think the same concerns apply should any of the 3 parties to this litigation want to, during their closing, replay Ring camera video. We don't have a ton of video, but the video that's been admitted, or the 2 music videos, et cetera, that is different fundamentally and conceptually from witness testimony. And that's the line I'm drawing, is that it's the replaying witness testimony to me is like handing the transcript during your closing. Hey, I just want you to have this transcript during my closing. This is what the person said. And it's not prohibited, but it's also not error for the court to exercise its discretion to say the witnesses have testified. the lawyers are going to share and Mr. Pritchett are going to share with the jurors what they say the witnesses said, and ultimately the jurors will be the arbiters of how that plays out. So you've made your record and preserved that. Those were the two rulings, other than we need to talk a little bit about the jury charge that had been left hanging, I think, from yesterday. Mr. Hiles, let me start with you and I'll work my way around. Other than the jury charge, anything else from the state?
I got some of the case law you asked me. I emailed it to the court and to defense this morning as to the firearm. Yeah, you sent Grant versus State, which was sort of like one of those gang cases that the appellate, for all that says is you don't have to have the firearm in an armed robbery. Well, if that's not what I was asking about. Well, no, the last portion of it, he also, the very last argument that was made was that he should also not be convicted of the possession of a firearm during the commission of an armed robbery. And they said the last point they make is Grant also argues that without the armed robbery conviction, his gun possession conviction must be reversed given our determination that there was sufficient evidence to support Grant's armed robbery conviction. This argument lacks merit. So, but that's not the question I asked, because I think the armed robbery charges properly go to the jury. My question was about the gun. I understand you are reading into Section 2 of the Court of Appeals opinion more than it says. But you have other cases. You lifted up a big stack. That was the main case that I was citing. Okay. What I want to say is, in that case, only one person said that there was a gun. The victim didn't, right? The victim didn't, and the case was for possession of a firearm during commission of the felony. That was based on one victim that was not, that said, or an eyewitness that wasn't a victim that said they saw a gun. Yeah. Here you have 7 people that say they saw a gun, that say that they were in fear of being shot would they not cooperate. So just like any other charge, I think the circumstances around it are fair for that to go to the jury, that a reasonable juror could make the conclusion if they decided that was a firearm. I agree with you. I wasn't trying to make folks engage in a thought experiment. I just hadn't bumped into it because mostly we try murders. And there sometimes is an armed robbery in connection with the murder, but there's always been a gun that was fired. And so there's not a good faith argument on the other side to say, how do we know that was a real gun? Well, how about the hole in the guy's head? And here, there are all sorts of reasons to be arguing replica, both about the music videos and this situation. And I think that lawyers can continue to make that argument, and that would be a question about the strength of the state's case and reasonable doubt, but not a directed verdict situation. Because I think there is the argument I think that was most persuasive to me, and it's circumstantial, but it's why would you bring a toy gun to a home invasion in Georgia in this day and age? People bring toy guns to. You could also say poor choice to do a home invasion in the first place. But I'm letting counts 19 and 20 go to the jury, and someday I may even find a case. Grant is not inconsistent with the decision I'm making. I just wished in Section 2 it put a little more meat on it, saying, "Hey, as long as someone thinks there was a gun, that supports the rest of it." I wish they did too. I know. Okay. And yeah, so the other case law I had already addressed, and I'll sit down. Okay. Ms. Mignot, other than the jury charge, which we'll talk about in a second, anything we need to take up this morning before we bring the jurors in?
As to counts, I think it was 19, Your Honor. I think directed verdict. I looked at case law all of last night too, and I saw the Grant case, and I realized that we have a peculiar situation here. We've never placed a weapon in the hands of either defendant in this case. So the issue you have is, if you're charging somebody with possession of something, isn't it true that the state has to prove that they possessed a weapon? I think directed verdict is warranted on 19. I understand why the court would be afraid to kick it out, because if the court kicks out 19, then
it's not a fear factor. Trust me. I had no reluctance saying 17 is out. I don't mind directing verdicts. It makes life simpler for everyone. And most of all, I'll follow the law. And I don't shrink from having to do that, but keep going.
So 19 says you're in possession of something. The state has failed to meet what it stated in the indictment that Mr. Robinson possessed. Any type of weapon. I can understand Granted saying, hey, if it was a gun that didn't work, there are cases out there where the person saying, well, the gun didn't work. And the Supreme Court said, hey, even if the weapon doesn't work or not, you had a weapon.
Yep.
We don't have those facts in this case. So that is the concern that I have as it pertains to the court's ruling as to count 19, because you have to possess it in order to use it. Yep. And the state has not met that burden to show that it was even possessed.
Okay.
In this case.
I hear you. You are a very persuasive advocate. I fear you've persuaded yourself too much, because I'm going to sound like a broken record, but I have found that through circumstantial evidence and the kind of iron vice that I find your client and Mr. Pritchett in, where we have two accomplices who, if believed, put your clients at the scene, not in the building, but at the scene before and after, with masks and with things that were taken from that household. And so there is ample evidence that the two home invaders had what looked like firearms. Both of them. The testimony is both guys had guns. Now, it differs. Like, was it a long gun, a short gun? Did it have a wooden stock? There are inconsistencies about the nature of the gun, but there was ample evidence that both of the home invaders had guns. If the jury finds that the home invaders are Robinson and Pritchett, the gun piece flows naturally from that. The part that didn't flow naturally, this was my hang up, but I've gotten past it, was, but were they really guns? And does that need to be proven? I don't think it was proven in the way that we typically see that it was a really gun, because a shot was fired. That's the kind of most, or the gun gets seized. The two easiest ways to prove that it was a real gun is someone is shot with it, or at least a bullet is discharged. Or the Mercedes gets pulled over on its way back to Voss Coleman's place, and two actual Dracos are taken from the car. We don't have any of that. And so I was wrestling with what if they were the props from the videos and they were sitting around Voss's place? Like, we can't go in there empty handed. They're just going to laugh at our masks. We have to go in with a baseball bat or a, hey, let's take this. And that's an argument you're not going to make it because you're going to say my client wasn't there. But I've already ruled that there is enough evidence in the record for the home invasion, armed robbery, and aggravated assaults, plus one ag battery, to go to the jury, because I think there is the state has made a sufficient circumstantial case that there is not another reasonable hypothesis other than your clients as to who would have, wearing similar clothes with masks, gone into that house, done what they did, and then suddenly your clients pop into the car with Riley and Kalish. Assuming the jury believes Riley and Kalish, they may not. But because I've made that finding, I'm denying your either renewed or slightly altered, but still I understand it, request for a directed verdict on count 19, because I think the evidence is sufficient for the jury to consider whether the two home invaders possessed firearms. This is sort of an all or nothing verdict. I don't see there being a guilty on some and not guilty on others, because the state has shown there was a home invasion and these people were robbed and they had guns pointed at them. To me, the question, you guys are going to structure it how you do, is who did it? That's it. It's not what happened. There are inconsistencies about tall or short or stocky or not stocky, monkey mask, not a monkey mask, but
tattoo or no.
I don't think the jurors are going to spend more than 10 seconds saying, was there a home invasion and did stuff get taken? Where they're going to struggle is, do we believe these women who don't seem to be being very seriously prosecuted and everything's getting lumped on these two guys? No digital evidence, no forensic evidence. It's all the things you're going to argue. But that's, I'm maybe misreading it, but the way I've been looking at this is it's a whodunit, not what happened. Not it was self-defense, it was accident. There was some confusion about it. It's these bad things happened. These guys had nothing to do with it. That's the defense. And the prosecution is these bad things happened. Really almost could be stipulated and the trial could have been a whole lot shorter. But these aren't the people who were involved.
And just for clarity, and I'm not asking this question just as gamesmanship. I actually do want to know. It's my understanding that if the state in its indictment say that my client committed a home invasion, is the burden on the state only to prove that a home invasion occurred, or is the burden to prove what they listed in the indictment, that my client committed a home invasion?
Oh, well, so I don't want to, I'm not the one arguing it to the jury. But of course, your client could be a party to a crime. He could have been, it's not the facts, but hey, I'm going to drive you guys there. The car will be running. I'm going to be there in the driver's seat. And when you come running out, Kalish and Pritchett with the drugs inside the white jacket, I'm going to speed us away. You know, from party to a crime or co-conspirator, your client could be liable for the home invasion despite never having set foot in the house. But that's clearly not the state's theory of the case. So the state has to prove a home invasion, and they need to prove that your client was somehow involved in it. The only evidence I've heard from the state in their argument is not he was a driver or a planner and that's it. It's he was one of the two with masks. That's what they've signed up for in their opening. But that's not what the law requires. You could be a party to a crime and have aided and abetted in some other way. But you know that. I mean, I don't think you're engaging in gamesmanship, and I don't mean to be giving you criminal 101 because you write criminal 909. But I'm not limiting the state in any way as to how they choose to prove it up. I was merely giving you, from having sat through 7 days of trial, the evidence sure seems to be shaping up as a home invasion occurred. The question is, was your client involved in it in any way? Because if he wasn't, then the state has proven that a home invasion occurred, and it's a not guilty on every single count because Tyrone Robinson had nothing to do with it. But if the jury finds that he committed the crime directly or in some other way aided or abetted in the commission of the crime, that's black letter law. I mean, then he is liable. Did they prove that beyond a reasonable doubt? TBD. But as I've been processing each of these counts for directed verdict or not, the part of the elements of home invasion, the elements of armed robbery, the elements of aggravated assault have all been met. I believe the state gets those to the jury. The hard part for the state is, well, who did it? And you know, you're free to argue it differently, that, you know, I don't think there was a home invasion and that these guys were all lying and they hit themselves on the head or they were so drunk they bumped into a wall. You decide whether that's a credible argument. It seems like the argument is these bad things happen, and Riley planned it and Kalish was there, and that's what we know. And there's nothing about my client, no phone, no all the things that you've been saying. I have found in my ruling on the motion for directed verdict that I don't know how compelling it is. That's for the jury to decide, but the state has presented enough that connects Mr. Robinson and Mr. Pritchett to having participated in those crimes that the jury may consider them in their deliberations. I'm not pulling it from the jury. Did I better explain myself?
I think I understand now where the court's position is. That even if the state is unable to prove who's done it, the court is inclined to send it to the jury if they can prove something happened. Something happened.
So again, I'm not finding that the state has proven anything beyond a reasonable doubt, but I am finding, now I'm repeating myself from yesterday, that there is more than no evidence that Mr. Robinson and Mr. Pritchett were the two guys who went in the house. It's circumstantial in part, but there are conflicts in that evidence. But the test, as I understand it, and frankly, as how you enunciated it in your opening to your motion for directed verdict, is if there are no conflicts of the evidence and the record demands a verdict of acquittal, I must do that. And when you and I were verbally sparring a little bit, it was my pushback that I think there is evidence, whether it's compelling or not is for you to argue and the jury to decide, but there is evidence, circumstantial in part, that puts Tyrone Robinson and Max Pritchett in the shoes of the people who did the home invasion, meaning the two guys who walked in. And so because I think there is some, not none, then the jury ought to deliberate and consider those, because my finding was that it would not be an irrational verdict if the jurors came back with a guilty verdict on the counts that I'm sending to them. I just don't know what they're going to do. I don't think it would be an irrational verdict if they said not guilty, which is what we've got a jury for.
Understood.
Okay.
Thank you, Judge. I appreciate the time.
You bet. Mr. Pritchett, I am going to get to you, but I want to go over the jury charge. So let me share my screen, and then you can give me an update on your guy from Maryland.
I wonder if the judge already knows, because nobody's in the courtroom.
I'll be right back. The OneDrive isn't working. I got to send it to us.
Judge has bailed. All right. I think you guys, we might have nailed the poll. I'm not sure if the witness showed up. Wonder if Mr. Pritchett and Mr. Robinson ever just want to talk to each other. Like, hey, man, what's up? Hey, you think we're going to go down for this? This is crazy.
Need some protein?
I think so. Water ain't working.
Need some protein.
That's fine.
We did a poll yesterday. 80 to 20. 80% felt that Mr. Pritchett's friend, Abdul something, would not show up from Maryland. I guess he's in Maryland. I think if he does show up, I think the same 80% think he would try to present alibi information. Judge is back.
All right, on your screens is the revised jury charge, and if you look on the top of page 4, I added a sentence to credibility of witnesses based on a submission from Mr. Hiles. It's actually an important one for the defense, and I appreciate him catching it. In telling the jurors what they can consider in assessing credibility, I've added that sentence about considering a motive for testifying, including pending prosecution or grants of immunity. Mr. Hiles, any objection to the addition of the sentence it's a distillation of what you submitted. Any objection to that?
No, I mean, it's not something I exactly wanted, but I thought it was necessary.
I think it's wise to put it in. Ms. Mignot, any objection?
No, Your Honor.
Okay. Is that screen not working?
Yeah, I was lost.
Okay. Well, I'm going to get you as unlost as I can. We'll see if we can get it to work.
Yeah, the states can use every minute of their 2 hours.
Turning on?
They're the ones that provided the case law for the judge.
We won't
reminded him that this is a capital case. What does it mean to be a capital case?
Is it a good icon or a bad icon?
It means the maximum penalty.
Oh, but it means like getting the keyboard over there? There's a mouse.
The maximum penalty.
Hey, did Mr. Williams end up showing up? How you doing, Mr. Williams? You're going to tell me what your plan is about hiring counsel or working with Ms. Feely.
What?
I'm going to get Mr. trial.
Mr. who? Okay. Is that someone you've actually hired or you're in discussions with him?
I just have to give him the man. He was going home, but he said that he couldn't come because y'all had trial. And he has trial also.
Okay, so the excuse would be that he has trial, not that we've got trial, because here you are, and here I am, and we're talking. Tell me if Mr. Melnick had been able to make it today, and I said to him, hey, do you know Mr. Williams, and have you and he talked about the financial arrangements? What do you think he would say?
I got phones. Sure.
Okay, no, we don't need to bug him. So if we... Pardon me? You know what, Mr. Melnick will, I'm sure, let me know. If we put this case back on our next trial calendar, any reason to think you wouldn't have brought him on board by then? Okay. Then I think that's what we'll do. Ms. Nix, any objection to that?
Next trial calendar is in May 16th or May 30th?
I'm going to talk with Ms. Nelson, probably for your sanity. We do the May 30th one. Plus that gives Mr. Melnick a little more time to get up to speed. All these are not complicated cases, but you get him discovery, et cetera. So I've got the May 30th draft to review, and we'll just I think it's 2 cases.
Yes.
Yeah, so we'll pop them both on there. Ms. Feely, you remain, or will it be Ms. Rios?
It will be Ms. Rios, but I'm happy to send the discovery to Mr. Melnick.
Okay, but until Mr. Melnick files an entry of appearance, and that's what Ms. Nelson will do today, is shoot an email to him saying, if you're on board, we need that entry of appearance.
Handling some other business in the middle of this case.
Plugged in, and we'll add this to that May 30th trial calendar. Okay, all right, any questions, Mr. Williams? All right, so your mission is to get Mr. Melnick to file that entry of appearance.
Should you choose to accept it.
All right, see ya. How's that monitor working?
The Teams icon is on.
Okay.
I just turned it.
Yeah, because we're going to press on, and I will ask Ms. Nelson to have IT come on down. So do you, Mr. Pritchett, have any objection to me telling the jury about the fact that they should consider motives that some of the witnesses may have had to testify to include pending prosecutions or grants of immunity? Okay, great. The other change, if you look at what's on the screen now, the other involved parties, this used to say something about prosecuting the principal or whatnot. And Mr. Heil submitted some language that still didn't fit. So I wrote this. I'd ask you all to read it, and we'll start with the state and move on down the line with your thoughts.
Everyone read a sentence and pass it on. It is not relevant to your deliberations that other individuals who may have been involved in the planning or commission of the alleged crimes are not being prosecuted.
I would object.
Okay, tell me your objection.
I would prefer the language the court had previously.
Okay, the language I had before from the pattern was to me inapplicable because it referred to the fact that someone who didn't directly participate was being prosecuted and someone who directly participated wasn't being prosecuted shouldn't be something that confuses the jury. But those aren't the facts that that's not the structure that we got here. The state's thrust of the case is direct participants, not they were planners or aiders or abettors. And so that charge didn't fit.
There is evidence in this case regarding that. And in fact, some of the questions we got from the jurors was regarding that.
It was regarding why is Voss Coleman not being prosecuted?
That's why I preferred the previous format that the court had.
Okay. All right. Mr. Pritchett, I don't know how good your eyesight is. Are you able to read what's on the screen there?
Kind of. We're at
there's that highlighted thing that says other involved parties. And so it's just that one paragraph below it. That's the only thing new on that page. I can read it out loud if you can't see it. I apologize for this setup, but IT woes beset us again.
Judge, I don't mean to like say you're not smart with tech, but you could actually make this a single page view and make the boards a lot bigger so we could read these.
All right. Do you have any objection to that language?
I'm going to adopt what
Ms. Mignot said? Okay. I'm going to leave it in as is. I think it is more properly tailored to the process that the posture that we're in now. So what that leaves is...
I just want to take exception on the record regarding that.
Yes, ma'am. Whoops. What that leaves is...
Mr. Pritchett, are you
what
going to
we're going to do
testify?
with Mr. Pritchett. Because that will affect the one highlighted section on the screen that remains in the jury charge. So, Mr. Pritchett, when we left yesterday, you shared that there were maybe some witnesses that you might have testify, and you explained you weren't 100% sure if they'd show up. Any sense of whether Mr. Abdullah showed up?
I got back to the jail at 9:30, so I couldn't only make one phone call. So it abrupt all my plans to get him here. So actually, I did not think it was going to show.
Okay. Do you have any other witnesses that you plan to call?
Due to the lack of preparation, I don't.
Okay. When you and I had the important conversation about your right to testify and your right to remain silent, your initial answer was, do I have to answer now? And I said, yes. And then your answer was, I don't plan to testify. But because we had to end at that point anyway, I told you I would revisit it this morning. So I need to know, you still understand, and I found that you did understand your rights to testify and not testify and the consequences of both those. I'll tell the jury not to consider it in any way against you if you remain silent. If you do testify, you got to answer all the legally proper questions from the other lawyers in this case. Do you maintain your decision to not testify?
Yes, I'm going to maintain it.
Okay. Then what we'll do in a moment, and I'll give Mr. Hiles a chance to move equipment around if he needs to, is we'll bring the jurors in. And when they're in here, I will turn to you and refer to you as the accused and ask you if you're going to present any evidence. And you can respond any way you want. The typical answer, if you're not going to, would be, I rest. But you can explain it however you want. But you're telling me that the impact of what you're going to say is the equivalent of I rest because you're not calling any witnesses to include yourself. Is that correct? Okay. Ms. Mignot, did you have a chance to speak with Mr. Pritchett about the order of closing arguments?
I did not.
Okay. Mr. Hiles, do you need to set up the equipment for part one of your closing, or it's only part two?
It's only part two.
Okay. Why don't you get your PowerPoint ready to go?
Can you please send me that language you just edited with other parties so I can update the PowerPoint that we're about to show to include it? because it's not exactly how you just changed it. I want it to be on point.
I think they said they deleted it it was accidentally deleted or something.
You're talking about other involved parties, the thing to which Ms. Mignot and Mr. Pritchett are accepting.
Yes.
Yeah, I'll send it to you.
Just to avoid any objections.
You know, the screen will be doing the first, leading the wall portion, the first part.
Okay.
Yeah, can you copy us on this?
Sure.
You've already emailed this draft to us?
I didn't because I did it this morning. So I'm going to send it to you as well.
Yes, ma'am. Thank you.
And I will get a final version of the jury charge printed out so you guys have a hard copy for when I give that. All right. So are you, other than getting that language, are you ready to go, Ms. Green?
Yeah, just need to put that in. As soon as I get it, put it in, I'm ready.
Okay, it's been sent.
Okay. Thank you. Got it.
It's a long process. It's tedious at times, but it's necessary so it doesn't end up in an appeal.
Good morning. It's the usual. Third time this trial. Wonder we're not on the record right now. If we, for our next trial, put that over there, so some jurors could see here, and then I also could see what's on the big screen. I just go into other courtrooms, I'm jealous because the judge isn't behind these screens and can't see. Yeah, we need to, they got to fix the lab. I'm making a list to get IT.
Do you want any suggestions from the state in, Ms. Feely left, but
I do. In fact, I'm probably dragging you in for one of the sessions so that you can just bring stuff and say, look, and because I tell them there's lag, and like, we don't see the lag, but you're good at creating lag.
That's a compliment.
I mean, the lag's always there with Zoom, but it's,
but just the fact that you couldn't play that big file, like it kept kicking you out of Zoom. That's not your fault. This needs to work. And so I don't.
DeKalb County's got some new equipment that it's like tailored.
So the problem is they can't say, hey, McBurney, you get this. There are 20 of us. And so it's 20 times whatever we do. And so this is what we've got, and they need to make it work better. Okay.
IT is still doing IT stuff, trying to get ready for the closing statements. Once everything's in position and everybody can see, including, most importantly, I would say, the accused, he has a right to see everything that's going on as well, so he can consider it and make objections if needed. Then they're going to bring in the jury, and we're going to start with the closing statements, which will come from the state first. The state argued yesterday that because this is a capital case, under Georgia law, closings should be 2 hours in length, up to 2 hours. The judge is not a big fan of long closings, and he's like, I'd rather you don't do that.
Okay, now we
Case
don't
law
have Mr. Rivers.
supported the argument, so the judge acknowledged 2 hours it is, but I advise you not to use them. And because that
we'll
could
work on a verdict form. I got one from Ms. Mignot's team, but I'll circulate verdict forms for you all to review.
We anticipate that Mr. Pritchett, the accused, is going to rest without presenting any evidence, including testifying in his own defense. He got back to jail at 9 o'clock last night. It was late. He was only allowed to make one phone call and was not able to call his buddies to show up to testify in his defense. The judge basically responded and said, well, you should have thought about that before you decided to go pro se, because a lawyer doesn't have the one phone call restriction. And
Hey, I'm just, while we're in waiting.
Sure. What kind it is?
Yes, to see if we have it back there. We
Okay.
may very well have it. Okay.
Thank you.
Steve whispers really loudly, but their mic's off. The IT guy's like a statue working on that over there. Ooh. Get to see some of the court staff there briefly. I really think Mr. McBurney is a great
Let me know
judge.
when you're ready. All right, we're back on the record. Let's bring the jurors in, please.
I think the prosecutor's trying to pull off a Rob from Law and Lumber look. Not doing quite as well as one might expect, but it's a valiant effort. Other than the hands in the pockets. What's with the hands in the pockets?
Ms. Mignot, did you two speak about who's doing first closing? If you'll just huddle up and...
I think he's nervous. Witness no-showed because witness was not contacted because the accused could not make phone calls after 9 p.m. on the jail phone, and he was only allowed to make one phone call, and apparently that was not fruitful.
All right, for the jury.
All right, so the jury, and take your hands out of your pockets, please. There we go. Jurors filing in. Wonder if they're dressed up for verdict today.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. Good to see you all. Last day of April, and when we left off on the second to last day of April, the state had rested. Ms. Mignot, on behalf of Mr. Robinson, had rested, which led to things we needed to discuss this morning. I'm going to turn to the accused and ask if you plan on presenting any evidence, sir.
No, just due to the lack of preparation, and failure to be disclosed of all the discovery. No, sir.
Okay, so you're resting?
Yes.
All right. So the accused has elected to rest as well. Much like Mr. Robinson through counsel, the accused has no burden of proof, and so he's not required to present any evidence, although he had the right to do so, and he's explained his situation. So the evidence is now closed, and we are left with two more steps before you begin your deliberations. Closing arguments, which will start in just a moment, and then the charge, the law that I will give you that you must apply to the evidence as you find it to be.
Thank you, Susie Mack.
I told you yesterday, because the state has the burden of proof, they go first and last. I think Ms. Green, in just a moment, is going to talk to you more so about the law that she believes I'll be instructing you on. And she doesn't have to guess. One of the things we talked about yesterday after you went home was the law that I'll be giving you all. When she sits down with part one, having completed part one of the state's summation, then by agreement, Ms. Mignot will present for one time, and one time only, on behalf of Mr. Robinson. And then if the accused wishes to give a summation or closing argument, he'll be given that opportunity. After which, as I understand it, Mr. Hiles will get up for what we call the rebuttal, or part two of the state's closing. Important for you to remember that nothing the lawyers say to you during their closings and nothing that the accused says to you during his closing is evidence. This is all an effort to persuade you, and that's a very appropriate thing for the lawyers to do. And you may find if a lawyer says, you remember witness X said this, you're right, that's what witness X said. But in the end, you all decide what the evidence is. And so you should feel free to be persuaded by the lawyers. But if a lawyer says, by golly, that witness said X and your recollection is different, of course, you're deciding what witnesses said, what was proven and what wasn't. But this is an important opportunity for the state to urge you to find the defendants guilty, for Ms. Mignot and the accused, should he choose to point out inconsistencies in testimony, gaps in the evidence, et cetera, and to urge you to find the two defendants not guilty. When they're done with their urgings, I'll give you the law that you must apply to the case. Ms. Green.
Here we go.
Share real quick.
Ms. Green is up. Probably going to use about an hour to an hour and a half is my guess, and then save half an hour for rebuttal. Oh, you forgot to update the heading that Lindsay Kalish and Lauren Riley are not included in this particular trial. They will be charged. They are charged, and they will face charges later.
Gangs, greed, guns, and lust. Now that the state's evidence is closed, you have more context to that statement. I want to thank you for being here for over a week, being patient, listening to the testimony. And now I'm going to go through, like the judge said, some of the law portions. It is your duty now. It's on you to be fair and impartial, to honestly seek the truth, to not seek doubt, but use your basic common sense and seek the truth. Follow the law as the judge will charge you, and a duty to deliberate. Everyone has to participate.
Make sure you say seek the truth one more time.
And you are to report if no one does, if someone refuses to deliberate. You are to consider the evidence that was presented, the exhibits, the testimony, and the photos. Now, this is everything inside the circle is a visual of what you should consider when deliberating. Everything outside of the circle is what you should not consider. You shouldn't consider your passion, any public opinions, your opinions of the police, if you don't like the police, public feeling, sentiment, sympathy for the defendant.
It's not, how's public opinion, public feeling, and sentiment?
If you disagree with the law, you have to follow the law as the court instructs you. Any conjecture, any prejudice that you may have, And any penalty or punishment, that's not your job. You are here for one reason, to give guilt or not guilty. Come back with the verdict. The penalty and punishment is something that's handled later. But inside the circle, you can consider the statements, everybody's statements, expert testimony. You heard from our game expert. Testimony of the witnesses, Lauren, Riley, the 7 victims you heard from, photos, documents, the videos, the text communications afterwards, that's evidence. Any motive to lie, that's credibility. You can assess that. The observation of the weapons that you saw, the elements of the crime, and use your common sense.
What weapons did they see? Just in the movie?
The presumption of innocence is something that the defendant has when he enters trial. He is covered with it. That's how the trial starts. But that presumption leaves once the state has provided sufficient evidence to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. And we've done that. That presumption is gone. Burden of proof. The burden rests upon the state. You heard that in opening, I'm saying it again. It's all on us. We presented the case of the state, and we are required to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There is no burden for the defendants. There is no burden whatsoever. It never shifts to the defendant and to introduce or prove their innocence. It's on us to prove our case. However, beyond a reasonable doubt is not a mathematical certainty. It's not beyond all doubt. You don't have to have every single question answered, but when you step back and you look at the big picture, do you still have doubt? A doubt of a fair-minded, impartial juror honestly seeking the truth. It's based on common sense and reason. It's not vague or arbitrary. It is a doubt which you can give a reason to based on the evidence that you heard, maybe the lack of evidence, or the conflict in evidence. You should be able to articulate it, not you just feel it. So maybe some of you guys drove throughout the week from your neighborhood to the courthouse, and you have become accustomed to our downtown traffic, 9 a.m., 5 p.m., and you probably had to stop at one of these places. How did you know to stop? Because it goes from the F down to the E. And if you're like me, unfortunately, wait till the light comes on. But you pull up to the gas pump, you put your card in, you hear the click in your card, it approves. You are allowed to pull the handle, push your grade, put the handle in the car, and then you pull the leverage.
And I've been doing it wrong all these years.
You can feel, you can hear the gas going through the piping into your car. You can smell it. And then you see the numbers going, right? You don't see gas going in your car. But
what if there isn't?
You have used an inference. You have used your common sense. You're seeing the numbers going up, you know it's going to get charged. You are filling up your car. You hang it up after it clicks. You put it back into the rest.
I need more detail.
And you get in the car and you turn your car on. And what happens? It goes from E to F. And now you feel comfortable driving the car for a couple of more days, depending on which kind of car you got, a week or two, because you know your car is full. That is an example of circumstantial evidence. That is common sense. Not everything is going to be direct. And you can use circumstantial evidence.
Worst example ever.
So let's talk about direct and circumstantial evidence. The law assigns no greater weight to direct evidence or circumstantial evidence. Evidence is evidence. Now, direct evidence are things that you can see, you can hear, you can directly sense, such as smell, taste, touch. It is evidence that points immediately to the issue in question. It may be brought into court in the form of exhibits, testimony, direct testimony of witnesses. So the sounds of yelling when they enter the home, or video footage of two armed males entering the home, directly saw that. Head injuries, you saw that in photos. Pools of blood on the floor, that was seen. Eyewitness statements, you assess their credibility, but they saw it, and you get to assess the truthfulness of that. Circumstantial evidence would be a proof of facts or circumstances by using direct evidence, from which you may infer other related or connected facts. They are reasonable and justified in light of your experience. What's some circumstantial evidence we had in this case? Observations after the home invasion. You got two men in the car. You heard from Kalish and Riley who those two men were, Robinson and Pritchett, and they threw out phones and wallets out of the window. You heard from 7 victims who said those items were taken from them. You're connecting the two. Asking for money afterwards. The messages of the girls asking for money afterwards. You can make an inference from that. Leaving the door unlocked. That's important because you heard from the 7 victims, well, not all of them, but most of them said that we kept the door locked, we shut the door, we washed the door. But what happened when Riley ran out the door? It was not locked, it was not shut. Here's another one, you rarely see this in Atlanta, right? But let's say you wake up this morning and this is what the city looks like. And you didn't see it snow, but you can reasonably conclude that it must have snowed last night. There's snow on the ground. Credibility. You, the jurors, must determine the credibility or the believability of witnesses in this case. In deciding this, you can consider all the evidence and testimony that this case includes. The witness's manner of testimony, their means and opportunity knowing the facts in which they are testifying about, the nature of the facts that they're testifying about, the probability or improbability of their testimony, their interest or lack of interest in the outcome of this case, their personal credibility as you observe it. You've been living in life, you've been talking to people, you've been assessing character all your life, credibility all your life. Keep it going when you go back there to deliberate. What makes sense? Party to a crime, sorry. A person is a party to a crime.
It's a crime party.
Only if that person directly commits the crime, intentionally helps the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. This is a good example from movies. We all see bank heists, bank robberies in movies. If you have 4 men that drive to a bank to commit a bank robbery, one is the driver. He never gets out of the car. Another is the lookout. He gets out of the car, but he doesn't go in the bank. He just stands outside. Then there's the man with the gun that goes into the bank and attacks the guard. Then there's the man without a gun inside the bank. Let's say he's collecting the money. He's working the safe. Who is going to be charged with armed robbery? All of them. They're all participating in together. And the man who attacked the guard with the gun is, under the law, it was as if they all had a gun and attacked the person. They are all charged with the acts of each other. The existence of a conspiracy may be established by proof of acts and conduct, as well as proof of any expressed agreement. When persons associate themselves in an unlawful enterprise, an act done by any party to that conspiracy to further the unlawful enterprise is considered to be the act of all the conspirators. However, each person is responsible for the acts of the others as long as they are the natural and necessary acts to further that conspiracy. When one or more persons conspire to commit any crime, any one or more of those persons does any overt act to bring about the object of the conspiracy. So the planning happened. What was the next step? Bringing masks and guns, that's an overt act. Taking a picture, texting it to the other car, that's an overt act. Presence, companionship, and conduct before and after the alleged offense may be considered in you determining whether or not those circumstances, if any, give rise to the existence of a conspiracy. Other involved parties. I know we heard about Young Babies, Boss Coleman. Any party to a crime who did not directly commit the crime may be prosecuted for the commission of the crime upon proof that the crime was committed and that the person was a party to it. Now, and the court will read this to you as well, and you will have this back there with you. This second crime, it is not relevant to your deliberations that other individuals who may have been involved in the planning or commission of the alleged crimes are not being prosecuted, or that only some of the defendants charged in this case are on trial. You are considering only the 2 defendants presently on trial. Intent. Intent is purposely doing an act. Intent can be inferred from the proven facts and circumstances or by acts and conduct. It may also be inferred when it is, you see this again, the natural and necessary consequence of an act. It is natural and necessary, or it is a natural consequence that if you go in to rob somebody and someone fights you back, that someone may get hurt in your conspiracy. You may find intent through words, conduct, demeanor, motive, or any other circumstances connected with the acts related to the alleged crimes. So let's look at the before. The before, it goes to the intent and conspiracy. So before the home invasion, there was a discussion. You heard testimony from Lauren and Lindsay that there was a discussion amongst the defendants about what they're going to do. They brought masks. They brought firearms. They did not bring their phones. Only the girls had their phones. The other phones were left at the house. You can use that as evidence of the intent to commit. They knew what they were about to do. Leaving Lindsay's phone in the car. You saw Lindsay and Lauren go into the house. Leaving Lindsay's phone in the car would be that form of communication. Why else leave it? And turning off the headlights. You saw video footage of Lauren circling the block with the lights off at night. You can use that towards intent. Parking down the street. There was parking right outside the house. You can use that. During the incident, during the home invasion, like I said, texting Lindsay's phone from Lauren's phone. Lauren running from Wiley Street, running from the front door all the way down the street to her car. You can use that as intent. Lauren circling the block. and taking the victim's phones. After the communications about the defendants discussing money, the split of money, or getting money, and then tossing the victim's phones. You can use that as intent. What was that the intent to do? They took at gunpoint, and then they tossed them to not be able to call the police. I don't know, but they tossed the victim's phones, and you heard testimony that later found. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law. It's the intent to commit that act that is prohibited by law. So let's run through the charges.
Got like 19
I wrote them down, and I think a way to digest it. 1, home invasion. That's count 1 of your indictment. Count 2 through 8 is armed robbery. You got 7 counts, you got 7 victims. 9 through 15 is aggravated assault with a deadly weapon. 7 counts, 7 victims. Aggravated battery. 1 count of aggravated battery, and that was to, remember, DJ Victor, the time. Aggravated battery. Number 18, participation in criminal street gang activity. You heard all about this yesterday. That's count 18. Count 19, possession of a firearm during the commission of a felony. And then 20, possession of a firearm by a first offender probationer, as it relates to Mr. Pritchett. You heard that yesterday. Kind of broke it down into 5 parts. Home invasion. Enter the residence of another person without the authority, with the intent to commit a forcible felony while in possession of a deadly weapon, while the residence was occupied by someone with the authority to be there.
Seems like
you
it
heard
checks all the
testimony
boxes.
from multiple people that Riggs was written out that spot. That was Riggs' place. He invited them, he wanted to be there. They were there. The defendants in this case, Robinson and Pritchett, entered without authority, with the intent to commit a felony once inside. You have evidence of that. While in possession of a deadly weapon. You heard 7 people. Well, you heard, I believe, 6 people say they saw a firearm. 1 person said they had their eyes covered. Armed robbery, broken into 4 parts. Took another person's property directly from the other person or the immediate presence by using an offensive weapon with the intent to commit theft. There is direct evidence. There are some eyewitnesses that said, I saw him snatch this off of me. He held a gun to my eye, to my face. But then, remember Christian Hooper? He said, I was curled up in the ball. I felt someone grab me at my waist, at my pants, and then I realized my wallet is gone. I came with my wallet, now my wallet is gone. After the 2 men came in, that's you can make an inference from that. His items were stolen from him. A person commits an aggravated assault when he attempts to commit a violent injury to another. The assault was made with a deadly weapon. Actual injury is not required for aggravated assault, and a firearm is a deadly weapon as a matter of law. So pointing at, toward, or in the direction of Holden Carmody, Noah Walker, Rebecca Mears, Jackson Buckingham, Vagat Katani, Christian Riggs, and Christian Hooper is your aggravated assault, each one of them. Aggravated battery. Aggravated battery is when a person commits an aggravated battery when he maliciously causes bodily harm to another by seriously disfiguring another person's body. greatly injuring the appearance of the victim's body. Disfigurement does not need to be permanent, but can be temporary. This goes to Bhagat Katani's head. He told you that he still has scarring on his head as of now, but you saw the pictures of where he was at the time. Malice. Now, aggravated battery has an additional element of malice. Malice is not ill will or hatred. Malice is an actual intent to cause a particular harm produced, bodily harm, without justification or excuse. Malice is also the wanton, willful doing of an act with the awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstance connected with the offense. You heard direct testimony. In fact, one victim almost broke down. You heard direct testimony that Victor was curled up in a ball. It's almost as if they picked on him. He had nothing. He wasn't fighting back. He was giving up. And what happened? Curled up in a ball on the floor, he's still getting his head beaten, stomped on. That's malice. Count 18, criminal gang activity. A person commits criminal street gang activity when a member or an associate of a gang participates in gang activity while breaking the law. So you need the existence of a criminal street gang, which has been proven. You heard from the gang expert yesterday. The defendants are associated with the criminal street gang. We don't have to prove membership. Association is enough. The defendants participated in the charged criminal offenses. You have evidence of that. And then the nexus between the crime and the gang. And you heard that from the gang expert yesterday, that committed to furthering the interests of the gang. Count 19, possession of a firearm during the commission of a felony. A person possesses a firearm during the commission of a felony, and in this case, home invasion, armed robbery, aggravated assault, and aggravated battery, sorry, assault's there twice, and aggravated battery are all felonies. The court's gonna tell you that. And a firearm includes any handgun. Some people refer to it as a AR style pistol. Some said a pistol. I think somebody said a rifle. Firearm. All defendants, party to a crime doctrine, all defendants. It applies to all defendants. The last count, and remember this is to Max Pritchett for his previous burglary. A person possesses a firearm when a person possesses a firearm while on probation for a felony as a first offender. Home invasion, armed robbery, aggravated assault, aggravated battery are all felonies. And the court will instruct you with that. Thank you. For this time, I'm going to stop with the law, and then you will, after you hear from the defense, you'll then hear from the lead, my co-counsel, Mr. Tiles, about what else you should find that these defendants are guilty. Thank you.
Thank you, Ms. Green.
She kept it short.
Ms. Mignot.
I thought she was going to go much
You
longer.
are up.
Thank you, Aaron.
Probably only about half an hour of time used up. Ms. Mignot, she has 2 hours. Start the timer for her now. Maybe take down the state's PowerPoint while she gives her presentation. That might be nice. I was not expecting that. I was expecting her to then go through the entire case, describe the events. Looks like the rebuttal is going to be lengthy then. Ms. Mignot, Judge said you could start about a minute ago. benefit of the doubt and say she gets a reset.
Good morning, ladies and gentlemen of the jury. On behalf of my client, Mr. Tyrone Robinson, his family, my entire staff, including my staff here, and our firm, we'd like to take this opportunity to thank you for your time and attention to the evidence in this case. If I look nervous, I can assure you it's not an act. I am nervous. And the reason I am nervous is because I have this young man's life in my hands today. I have removed my mask to make sure that the final opportunity I have to address you all as jurors, that you can hear and you can see movement of my lips. When we did opening statements for you, we told you what the evidence would be in this case. And as attorneys, we're trained. Do not tell the jurors what you're not going to be able to show in your case in chief. And I submit to you that I'm about to point to you that I showed you what I believe the evidence in the case to be. If you have any doubt about how this case came about, I'm going to give you the theory. As I prepared to address you today, the things that I did was pray, pray, and pray again. Because I did not want to say anything that would cause you any alarm or to upset you. So if there's anything that I have done throughout this entire trial, please, please, please do not hold it against that young man. I'm an advocate, and I've been taught advocacy skills. And sometimes advocacy can come across as arrogant or harsh or aggressive, but I assure you, please attribute it to the passion and the oath I took to represent individuals like Mr. Robinson in my quest to uphold the Constitution of the state of Georgia and the Constitution of the United States. You all were sworn twice in these proceedings. And the reason you were sworn is because we're asking you to give us the truth. When we're asking you questions, we're trying to select, trying to determine who can be fair and impartial. And fair and impartial, ladies and gentlemen of the jury, is a conclusory statement. How would I describe it? I don't like her pink suit, but I'm fair and I'm impartial. So I'm gonna look at the evidence and I'm gonna decide this case based on it. I don't like how she cross-examined, but I'm fair. And I can put that out of my mind and I can focus on the evidence in this case. We're gonna talk about the pink elephant in this case. It's a subject that we as human beings don't like to talk about.
Pink elephant?
But it's a subject if we don't talk about it, we lose an opportunity to be the greatest country in the world. The state wants you to believe that this case is about lime green, slime green, highlighted yellow, but it's not. It boils down to its common sense denominator. What is that? Black and white. Our theory of this case, and what we believe the evidence showed you, is that you have two young white females that I told you in my opening are living a double life. In one life, they're wonderful children, they're going to college, they're doing the things that we as parents want them to do. And in another life, they're criminals. And I submit to you that the state decided, when this case started, that they like the girls and they want to help them. So what happened? Riley and Kalish conspired a plan to rob their friend from high school, Chris Riggs. Why are they trying to rob Chris Riggs? Because he is a drug dealer. He's an easy target. He doesn't have a whole lot of guns. He's gonna come with the ketamine. He's gonna come with the wax. He's gonna come with the gummies. He's gonna come with the marijuana. But he's not gonna come with a gun. Because he's a drug dealer that schedules parties and invites our young children to partake. Is that a problem for the state? Evidently not. No charges. Remember, I told you in my opening statement, the state has the legal authority to treat you as a victim in one case and prosecute you for your crimes in another. There's no or, there's and. They didn't do that here. So what happened? The young ladies go down and they speak with law enforcement. Detective Maldonado. Detective Maldonado says, tell me everything. They tell him everything. He says, I don't believe you, because they first told him. Guess what? It's just two of us in that car. But I asked you to filter the evidence in this case through one theme. And that theme is, oh, what a tangled web we weave when first we practice to deceive. And I'm not just talking about Kalish and Riley. I'm talking about some of the state's conduct, district attorney.
Oh.
Because what they want you to believe is that this case had nothing to do with anything other than gangs, lust, guns, and the list they put up for you in their closing of their case. It's more than that. Detective Maldonado questioned these young ladies. And I asked him, sitting right there in that stand, they were suspects when you questioned them the first time. Yes, they were. But what we did is, we're smart for law enforcement. We question them first, we pretend like we're gonna allow them to leave, and then we bring them back in, read their Miranda rights, and then question them again. So how do we preserve our case if we're the state? We preserve it with immunity. Because if the statement wasn't obtained lawfully, how are you gonna use it if you're trying to get to Mr. Robinson? You gotta give immunity. So now the state decides to do what? To give immunity. Let's talk about the list of witnesses they called. Ladner, Grady, Weems, Bygrass, Buckingham, Heil, Carmody, Walker, Meir, Sluss, Hooper, Riley, Catani, Riggs, Kalish, O'Hare, Velasquez, Miller. None, I crossed them out, none of them put Mr. Robinson in the house. None of them put Mr. Robinson in the Mercedes. So let's talk about what the witnesses said. Let's break them down for you because we threw a lot of information. Ms. Latner, she's a custodian of records. Went through her pretty quickly. No information regarding who was involved in the incident. So the first witness the state gave you, no proof beyond a reasonable doubt. Mr. Robinson was involved in any crime whatsoever. Next witness the state called, Mr. Ayden Green, went through him pretty quickly. Does not know anything of the people involved. He doesn't even own the Airbnb. He's a tenant of the Airbnb, and he mentioned the name of another owner. And he rented the property to Chris Riggs, who's the next person we talk. Officer Roxanne. She's a responding patrol officer who met with the victims outside. She didn't even go inside Wilder Street. Why would a police officer that shows up and is a responding officer that's supposed to fill out a police report, take in, go inside, oh my God, I found drugs in plain sight. Wait, we have two situations here. We got a crime scene that I have to preserve everybody outside, ward it off. Let's make sure nothing is moving here so we can gather all the evidence and make sure we have the right people. That didn't happen. She told you she didn't go inside. She cannot identify Mr. Tyrone Robinson when I asked her. So no proof beyond a reasonable doubt based on this witness that Mr. Robinson was inside the house or outside the house or in the car or outside the car. Next witness. Jonathan Vibrex. He's a neighboring property. He had surveillance and he provided the surveillance. Shows two men, doesn't show two men anywhere on the surveillance video going into the car because that's important. That's important. The state talked to you about circumstantial evidence. You have to have a circumstance before you get to circumstantial evidence. You don't get gas in your car when you don't have a car. You don't get to a gas station if you didn't drive to a gas station. So when you drive your car to the gas station and you put your gas pump in there and you press and you didn't even have a car. They didn't even show you a car.
She's mocking.
But they want to talk to you about circumstantial evidence associated with gas going into a car at a gas station. This gentleman did not put it in there. Jackson Hiles. Jackson Hiles says, works in drug sales. Now, Jackson Hiles is a very confident young man. But he's confident because he has immunity. Selling drugs in Atlanta, bringing it from California. It was mind-boggling to me as a parent, not even as an attorney. You got through TSA. Nobody has any type of machinery that's screening that drugs is coming from California and it's making its way to Atlanta, and then they're flying to Texas to a concert. He testified there was $15,000. That kind of money at that age, within 28 hours in this city? Because remember, the testimony of one of his friends was, we were here about 28 hours. 28 hours they were able to make $15,000. Because he said, hey, I was coming here, I was gonna meet up with Chris Riggs I met him on social media. How do you think he met Chris Riggs on social media? Chris Riggs, remember, is the guy who's having the parties. The parties that Kalish and Riley had attended before. Drank alcohol, underage drinking, smoking marijuana, taking a dose of ketamine, something that can kill you. To hallucinate, to get a bigger high. What did he say? Can I identify the two people that keep? So even with this witness, you don't have Mr. Robinson inside the house, outside the house. The description of your assailants differ. One was tall, one was really skinny. There's two masks there. One went upstairs, one didn't go upstairs. The alleged victims were inconsistent. And they were inconsistent, ladies and gentlemen of the jury, because they were covering. One of them called 911. The other one says, hey, hang on. What are you doing? We got all these drugs here. I'm not trying to go to jail. We're not trying to take everybody to jail. We're just trying to sell drugs. Having a great weekend on our way to Travis Scott concert. Golden Carver disagreed about the state with the type of weapon. State is saying, hey, it was it's no, it's an AR, it's an AK, it's a short, it's a rifle, it's a pistol. We got descriptions all over the place as it pertains to a weapon. It doesn't place Mr. Robinson at the home. To get the home invasion, he's got to be there. Other than that, I'm the person who did it. My staff is the person who did it. Anybody sitting in the courtroom is the person who did it. It's not standard. It's beyond a reasonable doubt. And you can't even get him there through this state's witness. They conceded that in their opening. Oh, none of the victims are gonna say they know who it is. They don't know who it is. So what did we do? We twisted the arms of the two girls when they said it was just them. Because we know two people went in other than them. We don't know who those two are, but any two Black men will do. Especially if they're in rap. Especially if they rap. 3 or more of them, gang.
Especially if they rap.
Where they use profanity, gang. There's a saying we come up with, there's a saying, throw enough stuff on the wall, something's gonna stick. That's what's going on here. Noah Walker doesn't have a clear memory, was very intoxicated. Spoke about a condition I had never heard of Asian. Cannot identify Mr. Robinson as the person who took the cell phone. State's indictment says that my client, Mr. Tyrone Robinson, took a cell phone from Noah Walker. Through this state's witness, 0. No beyond a reasonable doubt that he was inside that house. Next witness, Rebecca Muir. She knew Christopher Riggs from high school. Riggs invited her to the party. She knew Noah Jackson. She knew Noah, she knew Jackson, she knew Holden. She said there was no interest to keep it alive. And what's peculiar about her testimony is, I asked her on cross-examination. So, did you see drugs? Nope. That's the see nothing, hear nothing, say nothing. I don't have immunity. Because remember, the person who brought the drugs, Riggs said, oh, yeah, $15,000 cash, lots of drugs, come to Atlanta to sell. That's what this was about. But he has immunity, so he has a reason to be able to share. What else did she tell her? 2 unidentified men after the girls left came in. That's not accurate. Because remember, one went to their car in a white jacket, which they switched according to the evidence, and one was still in the bathroom. She gave you men were Black. She said she laid on the floor with her chin to the ground. She didn't witness any of the violence. So the state's charging aggravated assault, aggravated battery. This witness can't give it to you. She can't place my client in the house at 1040 Wiley. She can't place my client in the Mercedes. And she can't place a weapon in my client's hands.
Thank you, Kiki.
This is not a guessing game. This is a prove your case beyond a reasonable doubt. Next witness. APD Officer Sauce, cell phone expert. And the cell phone expert gave you a cell phone record belonging to 2 females. 2 females' names listed on there. And then we want to play 3-card Monty. Well, although you see the name over here, don't pay attention to the name over there, because if I get my witness to just keep saying, Mr. Robinson's phone, Mr. Robinson's phone, Mr. Robinson's phone, then maybe the jurors will get confused and they'll say, oh yeah, he did say Mr. Robinson's phone. If you're not going to believe that the subscriber is not Mr. Robinson, then you're not believing the evidence. You're violating your oath. Because your oath is, oh, if that's somebody else's cell phone, other than law enforcement taking the stand and saying, that's Mr. Robinson's phone, doesn't make it his phone. Because every time I cross-examined on that issue, they would say, subscriber controls the phone. The subscriber controls the phone. I asked a magic question. Do you even know who that female is? What did Officer Sauce say? I don't know who that is. Could they have investigated? Absolutely. They have the taxpayer's checkbook as the DA's office. They could have determined who that person was. and if that person was connected. But they did not. They thought it was good enough to just say it. And it's not good enough to just say it. What do you tell you? Provided, just go back one second. Provided cell phone account subscriber information is for a female, does not know the female, and does not have any records that connect Tyrone Robinson's phone to the 1040 Wiley Street location on the day of the robbery. That is critical. Because now if we say, hey, Officer Sluss is correct. He's not Riley, he's not Kalish, he's telling you he doesn't have any phone records that would connect Mr. Robinson to the 1040 Wiley Street. Cell phone tower evidence is important, ladies and gentlemen. And there is no evidence that his cell phone was associated with Mr. Robinson and located at Wiley Street. So if you can't even place Mr. Robinson at Wiley Street, we're done here. We're done. That's a not guilty. You can't place him there. You can't place him. And when counsel's talking about circumstantial evidence, let me tell you what circumstantial evidence would be. Cell phone being there, although we don't see him, that's circumstantial evidence. But circumstantial evidence can't get past that. Because if we're using circumstantial evidence, then that means I'm there. Everybody in this room is there. That's not the case. Christian Hooper. Mr. Hooper went to the party, he went with the DJ. He only knew the DJ, Victor. He recognized Lauren from Milton High. Milton High is important in this case. Because I'm worried that what high means in Milton High is the kids are getting high. Woke up, saw two people in masks. Could not identify my client. Cannot say that Tyrone Robinson, he couldn't even tell if it was male or female of the two individuals that came in. And remember, there's testimony and evidence in this case that when they went to Young Van's house, there were two other people there. Who are those people? Did the state investigate? So those are two people that went? Next witness. Lauren Riley. This one is critical. When Ms. Riley was first questioned, she told Detective Maldonado that she went to Young Van's condo on November 7th, 2002. This is the night before the day of the incident. She sees two other people there. She doesn't recognize them. And she wants this jury to now believe, after she was in custody, because she told you to save herself, she says, I think it was baby Slap. I think it was baby Slap. I think it was Slap. Well, what do we have? The person referred to as baby Slap was not present upon her arrival. So whoever they're calling baby Slap, or whatever the state wants baby Slap to be, there's lots of baby Slaps on Instagram. That's what their experts say. Their detectives say. Slime comes up a lot, baby Slap comes up, Slap comes up. All those things come up because your handle can be whatever you want it to be. I could change mine to Slap tonight from the subscriber, and I have the account. What else did she tell you? Lindsay got the Snapchat from Chris Riggs with the picture of drugs in mind. Now, ladies and gentlemen, that's important because the individuals in the house really don't want you to know that we kind of posted this on social media. Because it's out there on Snapchat. Well, they only texted to one or two people. But remember, they can't control who those people share it with. So although we have approximately 20 people at the party, who else knows about it? Because Kalish was present at a party like that before at a hotel. And if she's sharing it with Riley, who else is sharing it of the people they invited? She saw 3 to 4 people walking on the street before entering the Airbnb. That's what she told. She did not know the person referred to as baby step. You heard me ask the detective, if someone's never interacted with someone before, and it's the first time and only time they've ever interacted with that person, it'd be difficult for them to identify. And he said yes. She and Kalish were the only two people in the Mercedes when they went to the party. It's corroborated by the home surveillance video of the neighbor, Mr. Vikers. Those home surveillance, according to the evidence, is motion activated. So you can see the car going around because it picks up the motion of the car, and you never see, the testimony of the evidence is that they saw a white female, but at no time did they see anybody else in the vehicle. There wasn't, we could see the silhouette of two people in the back, we could see the silhouette of three other people other than the person that we could see. There's no evidence of that. She changes her story. And let me tell you something, ladies and gentlemen, I am not crucifying anyone that says, hey, if I'm in trouble, I'm gonna save myself. She's human. Of course she's gonna try to save us. But what we're saying to you is, not at the risk of convicting somebody who she's not telling the truth about. Not at that risk. She left the party before the two people entered. She did not see when two people entered or leave the Airbnb. So if she didn't see anybody going in, and she didn't see anybody going out, and she told Detective Maldonado that she and Kalish were the only two people in the Mercedes, that's a not guilty. Mr. Robinson is not placed at Wiley Street. He's not placed in the Mercedes. He's not placed at Wiley Street. She didn't see anything happen that inside the Airbnb. So she can't even say, yes, the whole plan was that I was gonna go in and you know, Robinson was gonna do this, and Pritchett was gonna do this, or Baby Slot was gonna do this. Because remember, the names, Robinson, Tyrone Robinson, and Max Pritchett, she received from the police. She didn't give them that. If a police is investigating, they're supposed to be getting information. They're not supposed to be giving information. She cannot identify Robinson as one of the two people who went inside the Airbnb or exited the Airbnb after the robbery. We have no clue who those two people are. And we are not here to say, oh, no robbery occurred, no robbery occurred. Of course not, we're not the state. Something happened, people got injured. That is bad. But who did it? The evidence shows we know two people that are involved, Riley and Kalish. We don't know who else. The evidence is clear that there was illegal drug sales going on, rigs, heists. She is back in the blue jumpsuit. That's not a coincidence. That's a young lady who's not learning her lesson. Let's talk about the most important piece of evidence that we have in this case. Order granting immunity for Lauren. The most important piece of evidence that goes to motive to lie, credibility of a witness, believability of a witness, is this document. And this is not a motion by a defense attorney. This is a motion by the state. This is why we're gonna have a hard time in this country stopping the opioid epidemic. Because when we find a source where it's coming into our county, into our community, getting to our kids, we don't shut it down. You know what we call it? A business decision. Mr. Riggs, tell us about your business. That's what counsel asked him. Oh, it's a business in California, and we sell drugs there, and I brought him here for sales because I was trying to hook up, and that's what I was doing. They make him a businessman. That's how he was depicted. So a white young man selling drugs is a businessman, and a black young man selling drugs is a thug, a robber, a thief, and a gangbanger. Gotta stop the hypocrisy to save our kids. We've got to stop the hypocrisy to save our children. This young lady is dangerous, and it's because she is not being held to account. And I know the state's gonna say she's facing the exact same charges as everybody else in this case. Then she should be sitting right there, like everybody else in this case. Next witness. Mr. Riggs. He received immunity to testify. He's a business partner for Jackson Heights. It's a source of drugs to our children. It's here in Fulton County. It needs to stop. You rented the Airbnb. He said, I was not doing much legally. Who says that? Was selling drugs. You learned from high school. Remember I told you, Milton High. Sounds like the word high means they get high there. One guy had a gun in his pants. Riggs was trying to identify it, but someone he knew had come for him. When he said that, all my ears went up. And I said, did he just say that he was trying to recognize the person because he thought somebody had come for him? Do you know why members of the jury he would think somebody's coming for him? Because they have these drug parties and they advertise them on social media. And they do know if they are keeping the doors locked, it's because they're concerned, who did we push this out to that might, instead of coming to purchase, come to take? That's why he's trying to identify the person. What the last week? Couldn't tell you how tall the man was up the stairs. Didn't identify Robinson as the person who took his phone or his computer. The indictment says that my client, Mr. Robinson, took his stuff. And he says, I don't know who the guys are that came in the house. So now you don't have beyond a reasonable doubt that Mr. Robinson is one at Wiley Street, because I already showed you, we don't have any cell phone tower placing him there. We don't even have him with cell phone tower placing him where the state alleges his phone was left. Wait. I can understand you're saying your theory of the case is, no. His cell phone didn't ping at Wiley Street because they were smart. They were smart enough to leave their phones back at Young Van's place. Then why don't you have evidence in this case showing that the phone pinged at Young Van's place? Because it didn't happen.
She has a couple good points. There's some
you have to have
things that I'm super excited
to have circumstantial evidence. Text witness. Lindsay Cash. She told Detective Maldonado she and Riley went to Young Van's condo. So they were there. We're not disputing it. There were two people at Young Van's condo. Nobody recognized. Did the state investigate who those two people were? Did the state investigate whether those two people were involved in the robbery? Did the state take video footage from Young Van's expensive condo that's so expensive that somebody has to come downstairs and let you in the building? That's some tight security. Did they go do subpoenas to say, hey, let's see if we can see the car with the Mercedes with the two men that Kalish and Riley said left the condo with them, because the condo, trust me, is gonna have cameras in Buckhead everywhere. They're nice condos. They have security. Where is that evidence? You don't have it. You don't have it. Because they were satisfied with twisting the girl's arm with a promise. You just said what we're asking you to say. Just testimony, just testimony, just testimony. Because remember, none of the victims can place them there. So the only people who we can have place them there is you. One more lie for the road. But we'll just wink at it. State's motion to give them immunity, not a defense motion.
Okay, this is just tiny text.
Second most important document in this case. DR 16 was the first one, and DR 17. Immunity for Lindsay Couch. Immunity for Lindsay Couch.
Is there a reason she kept it tiny?
Get out of jail free card, get away free card, just testimony. Just testimony. State's gonna get up here and he's gonna say, that's only to protect what they say in court. Why do you need it? You need it because you questioned the girls and took a statement from them, violated their constitutional rights, and now you need to save your case. So how do you save your case? You give them immunity so they can come in and testify against these two individuals. That's how you save the case. And then we're long gone, nobody's looking. It's not on this. APD Scott here. He's a fugitive. We got through him really quickly. Because all fugitive means is you got a warrant, you don't know you have a warrant, I come get you. If I have a warrant right now, fugitive would be going to my house. Is she here? No, she's not here. She's in court. She's at work. Okay, let me go to work. Go to work and begin. What else could they do? They could call me and say, hey, guess what? We have a warrant for you. Would you like to turn yourself in so we can save the taxpayers some money? And I would say, yes, absolutely. I'll be there in an hour.
That's what fugitives do.
That's how that works. The word fugitive makes it scary. There's no charge here about fleeing or eluding. So don't let the word fugitive scare you. Okay. Did not find any items at the time of arrest that connected Robinson to the 1040 robbery. So there's not even a marijuana gummy wrapper or a wax paper or one of the cell phones or a wallet, or we found, him with a weapon, or we found something that is similar. Nothing, ladies and gentlemen, nothing connecting Mr. Robinson to 1040 Raleigh Street. Detective Carlos Maldonado. AirBnB was rented by Riggs. Riley said she and Kalish went to the party alone. Both Riley and Kalish were suspects prior to their interview based on conversations with Bears and Hooper. He knew they were suspects. He was supposed to Mirandize them before he questioned them, but he did not. How do you save your case? I give him immunity. Because there are only two people that can point the finger at my client and try to make you believe that despite cell phone tower evidence, or lack thereof, that my client is at Raleigh Street. No cell phones are placing my client at Young Van's condo. And if they said it, it's gotta be true. The two people that Detective Maldonado has admitted on more than one occasion on cross-examination, they lie. They lie, they lie, they lie. And when I asked both young ladies, how is this true? You know when you're lying. They don't. You don't. Neither women knew the names. Nobody knew Tyrone Robinson. Nobody knew Max Pritchett. Nobody knew those names. And what you have is, I cross-examined Detective Maldonado. Did you show your cell phone while you were doing research in the interrogation room to them when they started saying slime? Yeah, first I was looking for slime. So he's actually on his cell phone in the interrogation room looking up slime, looking up baby slag, or looking up slag, or looking, and then he shows it to the suspect and says, oh yeah, I showed her, but I didn't show her the picture. Okay. Got some swamp land for it. So say. Next witness. Detective Velasquez. This has absolutely nothing to do with my client, Mr. Tyrone Robinson. Court told you, took an oath and followed the law. That's got nothing to do with mine. He has no convictions. Period. Investigator Miller. All right. So this is the state's gang expert. What the state really meant to say was this is our coworker. And we've gotten a coworker that worked long enough in law enforcement that we could call on him and say, could you come and tell these jurors your expert testimony about gangs? When I cross-examined Investigator Miller, and I tried to give him the visual comparison to, I can be a member of a group, such as a fraternity, and the fraternity people could get in trouble or go steal stuff and bring it back to the frat house. And we could all consume it and share it. And of course, that would be for the benefit or the fragrance of the firework because we're all enjoying it. Just like how we wanted to give you the comparison of how the girls went and got the drugs and brought it back to the gang, and the gang used the drugs that was for the benefit of the gang. But he refused, he wouldn't concede that that would be the same comparison to a fraternity. And I submit to you, that's because of his implicit bias. If you think that an employee of District Attorney Fonnie Willis is going to come into this courtroom and sit on the stand and testify as a gang expert for the state, the coworkers, and he's gonna say to you, oh, no. It's more, you need way more. You need way more than just green, lime green, slime green, a handkerchief. You need way more than just finger signs that most people are doing in photos now. You need way more than a rap music video. I used to go to casting calls. I don't even think they had those anymore. If somebody would say, hey, guess what? You know, Home Depot's doing a commercial, they need extras, shoot down here, they're paying everybody $100, you know, for the day, and you run down there, you don't know anything about what's going on, you just know, stand right there, 15 people over that side, walk this way, and the cart, people filming, you're gone. These are young, impressionable kids. He's 19 too at the time, 19 and 20-year-olds. You can't treat them differently. Because we're asking you for liberty and justice for all. Not for how the state wants to present liberty and justice for some. No evidence that Mr. Robinson is part of the game. Or why is that? But he's saying it. If I say it, then that makes it. And he told you, if you're a member, that's not enough. If you wear the color, that's not enough. You must commit a crime. And his hybrid triangle is not complete. Let's talk about why. Milton High, if you look at the hybrid he showed you an engine versus electric car, and that it created a Tesla. This is really the hybrid that we ought to be afraid of. The drugs are not coming out of Atlanta, they're coming into Atlanta, and they're coming from California, based on the evidence in this case. And they're coming from students who went to Milton High together, and they're making it to Wiley Street, and there's the hybrid, that's what they look like. Because the evidence in this case is that is the picture that Kalish received, that she showed to Riley, and Riley said, great idea, let's go rob. And she wants you to believe that, oh, oh, we took the loot and then we went back to Young Vance's house. And when we got to Young Vance's house, we threw it out on the bed. Wait, we threw it out on the bed, but there was no sneaker. Wait, we threw it out on the bed, but then there was a sneaker. Wait, I think it's Baby Slap, but it's not Baby Slap, it's Tyrone Robinson. I'm not even sure if it's Rick, Rare, and Baby Slap that went into the house. We're all over the spectrum. This is the hybrid I'm concerned about as a parent. This hybrid. The Airbnb round. Where's a 19-year-old or a 20-year-old that says I'm homeless, getting money to rent an Airbnb? $15,000. Burden is on the state, ladies and gentlemen. They must prove Tyrone Robinson guilt beyond a reasonable doubt. The only people who say Tyrone Robinson was present at the party are the two women who got caught and now want to save themselves. And the state has decided to help with the saving part. So when I talk to you about first, we practice to deceive, this is deceptive. Know why I can say it's deceptive? Because the state did not show it to you first. You never said when the witnesses were on the stand, hey, did we have a conversation? Yes. Did we tell you immunity? Yes. And are you testifying truthfully despite your immunity? Yes. No. They made me tell you. This is part of the deceit. You don't want them to know. Because if they know this, you might not be fooled that we didn't prove our case beyond a reasonable doubt. Don't forget it. Burden's on the state. State values to get them. The state. Filter all the evidence through the old wise saying. Let's talk about burden of proof, because that's difficult. It's a conclusory statement.
I like this.
I've been practicing so long and I still have not been able to, do I make it a trash can that I can pick up and show how heavy the trash can is? Do I push, the air vent around? Let's talk about burden of proof. If you say, guilty beyond a reasonable doubt, that's the word. Has to be okay. That's it. Highly likely, not guilty. Guilt likely, not guilty. Possibly guilty, not guilty. Suspected guilty, not guilty. Perhaps, still not guilty. May not be, not guilty. Possibly not guilty. Unlikely, not guilty. Probably not guilty. Less than likely, still not guilty. Totally not guilty. This is it. You must find one, that Mr. Robinson was at Wiley Street. You can't find, based on the evidence in this case, that Mr. Robinson is at Wiley Street. We're done. So I'm guilty. Don't follow the rap music track. Don't follow the scare tactic. Don't follow the slime. Or the slime.
Don't follow the slime.
Follow the law. And the law requires that you come back with the only verdict that justice demands based on your oath. And that is not guilty on all counts. Thank you.
She kept it to 50 minutes on her closing.
Thank you, Ms. Mignot. Ladies and gentlemen, we're going to take a break. Ms. Rivers has been typing furiously as these lawyers have been sharing these important things with you. When we get back, I'll give the accused an opportunity to make his summation, and then we'll have the rebuttal or final summation from Mr. Hiles. Talk during the break whether you want to do lunch after all the closings are done or after the accused is done. We'll follow your lead on this one. But Mr. Hiles has a while to talk to you. So it could mean that lunch is more like 1 o'clock. If you can make it between now and then, that's great. Yes, sir. Logistical question.
What if we did an early lunch now?
How about this? Why don't we take a quick break? I have to give Ms. Rivers a break. And you could actually tell Deputy Gordon, we're not coming back. We're going to lunch. Of course, you're coming back, come back. But it would be early. So talk about what works for you all. And so either way, we've got 2 pieces of closing left, and then the charge that I need to give you all. And you now drive the scheduling bus much more. So if you want to do lunch now and do the rest of the closings afterwards, fine with me. Just let Deputy Gordon know in a few minutes after you've conferred in private. Don't talk about the case yet. No outside research, always and forever until you're done. But you will soon actually get to talk about the case, but not yet. See ya.
All right, the jurors, after that big closing, are ready for a nap.
Are you Investigator John? Okay, sit tight.
Food. Oh, Investigator John, welcome. So, interesting closing there by defense. I would say borderline unprofessional.
All right, Mr. Hiles, anything before we take a little bit of, don't go anywhere. I might actually leave everyone right here. We'll go off the record and turn off the mic in a minute. But if they're going to go to lunch, you guys can be gone for a while. So let's just hear what their answer is. You'll get a break either way. I'll just get from Deputy Gordon in a couple minutes what that answer is. Anything you need to get on the record right now?
I don't get anything on the record right now.
Okay, Ms. Mignot.
No, Your Honor.
All right. Mr. Pritchett, anything? Okay, sit tight, all be seated, and Ms. Rivers, we're off the record.
Okay, so just Mr. Pritchett left. The reason why I say that I felt that Ms. Mignot's closing was borderline unprofessional. I think she used I think she was marginally better with PowerPoint than the state, marginally better. We're not going to discuss race here, but that is something they can bring up if they feel that that's there. I think that's. I think if those elements were present, I think they would. They're fair game. That's all I'd say. I didn't see that during the trial as the motive. But I don't falter for that. I don't think it was a valid. I don't think it had merit in this case, but I think it's something they could bring up if they needed to. Matthew Harris says, trial tip number 583: do not wear Pepto-Bismol pink suit to trial. Stick with conservative colors with no patterns. You don't want the jury to focus on your attire, especially after you've said, let's talk about the pink elephant in the room. Yeah, that was interesting. What the problem I really had with the closing for Miss Mignot, I forget how to say her name, is that she basically accused the state of intentionally trying to deceive, basically accused them of unprofessional conduct. And those allegations are quite serious. They're quite serious. Not a big fan of that. I don't know, to save their case because they didn't Mirandize the 2 girls. They had to give them deals, but yet they're still prosecuting them. That part didn't add up. There were some jumps she made that I just couldn't follow. There was a lot of don't look here, look over there. and associating because they knew each other in high school. High school. That means they must be getting high. That's like a 4th grade joke, maybe 3rd. But she like used it as like the narrative for the presentation and the theory of the defense. I think she did a great job pointing out that there are only 2 people that say her client was involved, and they do have an incentive to testify to help their own case out. That was legitimate. That was very fair. But attacking the why haven't they charged other people? Why haven't they, why aren't they doing more to stop the real problem? The real problem isn't home invasion robberies. The real problem is drugs being brought into our communities by these high schoolers that went to the high school, and now they're getting people high, and that's the real problem. As a mother, I'm concerned. That part, that was just wave the flag over here. Don't look over there. Look over here. Didn't like that part. Was a little bit of name dropping. we saw some name dropping. If you're following, national news, you'll recognize some of the names that were brought in. Hello.
Hello, this is Chase Online with the 8-digit identification code you'll need to access your accounts online. Please press pound to continue. Para español, oprima 2. That was an invalid response.
Guess what? I don't
again.
have. I don't have any Chase Bank accounts.
Hello, this is...
I'm going to hang up on that one. Intermission scam call. Robotic. Don't overdo it. I think she had some valid points. She brought some very good points up. But the problem was the filler material she used, I think, lost me. The direction was not there. It wasn't clear. The way she attacked every single witness in ways that I thought were not fair. I guess that's it's her job to introduce doubt, but it seemed like some of them were a stretch. Both closings were below decent. Here's what we have left. We have the accused, who I'm just going to say right now, it's probably not going to be much better than what we've heard already. And then we have the state's rebuttal, which probably is going to be too long. Let's see. What's the deal? Are they going to go to lunch? This would be really useful if we could hear this, Judge. Nova says, what frustrates me is that I believe this case has room to be argued for the defendant. I agree. On the facts of the case, I think everyone's going to lunch. They're packing up and taking all their stuff. Which is crappy for the accused because he's trying to prep his closing arguments. Now he gets put back in the holding cell. But that's the deal. Yeah, they're grabbing stuff and going to lunch. There it is. It's official. Lunch is on the menu. Once again, order from one of the 4 items that are available to you. Here they are. All right. If they take a lunch, we're going to take a lunch. I don't know how long lunch they're taking. Let me check back. Turn this off. Back at 12:30. So a 45-minute lunch. We're going to take a half hour. Maybe 40 minutes. Is that all right? Taking ice cream today. It's nice and hot. I didn't get the chance to see the menu. The menu's right there. It's order by picture only. Just point to the thing that looks good. That is actually, it is a vegan lasagna. Those are zucchini. That's not hamburger. That's zucchini in there. What's on the right? I don't know. It looks like, what is on the right? I see celery. Some sort of paste. It looks, is that on bread? Is that Marmite on bread with, I don't know, is that okra? Wrong answer is only, what is the item on the right? It's supposed to be food. Looks like some sort of bread with a sauce. Maybe some celery in the sauce. No, I think it's a bacon mushroom burger on the far left. We've got a veggie lasagna in the middle, ice cream, and then something else. Looks like cantaloupe. Right-hand item looks gross. Chocolate chip cookie, no. Something on a shingle. Pancakes. I'm not seeing pancakes either. It's chutney on papadum or chat. Indian cuisine. Not a wrong answer. You're probably right. It's probably spicy too, is my guess. It's an Indian dish. It's probably very spicy. Can we please add a sushi option? Not on our budget, unfortunately, Francesca. Tax dollars just can't afford flying in the fresh fish. No baked cookies. It has pores. Its skin has pores. All right. On that note, we're going to take a little bit of lunch. I'm excited to see what the accused brings. We're up to 97 times. We might get to 100. Might get to 100 in this trial for the accused. But I'm excited to see what he brings in his closing statement, because he's got a lot to say, and he's not the worst pro se defendant we've ever seen. He started out pretty badly. He started out like on the Darrell Brooks level, but he's not the worst we've seen. He has learned a lot. He has been taking copious notes during the other defense presentations and arguments, and sometimes he just mimics or mirrors what they say. But I think he has something a little different to offer than what they did, and we might hear something good from him, like interesting good. I think as far as having not presented any evidence, it's very difficult to really have all the pieces necessary to spin a new theory of defense based on what we've heard. I don't think he drew out enough information or answers, testimony from the witnesses on cross-examination that would fill in the gaps for the puzzle as he wants to build it. But it's going to be interesting to have him put it together. It does. I do get the feel that with Mr. Pritchett, he has been sort of caught between wanting to question and ask and pin people down on things that he knows personally are wrong, like the facts are wrong because of his involvement. He knows they're wrong, and then knowing that if he asks the question, it implies his own guilt. So he's got this careful dance he has to do, which we'll see if it trips him up a little bit. Would you mind portaling us to Brandy for the lunch break? I can do that. We can portal over to Brandy. Brandy's following the Karen Reed trial, which is wild, guys. It's wild. It's a huge trial. It's massive. I realize most people are there. If you're not following it, we're in the minority. But let's see. I'll do a redirect to Brandy. Brandy, by the way, if you guys jump over to Brandy, make sure you hit the like button. She did hit 20,000 subscribers just this week, and it was really, really cool. We're super excited for her. So make sure when you jump in, hit the like button and congratulate her on the 20,000. For us, we really appreciate her and her channel, what she does. She's done a ton of work on this one, and I've got a lot of respect for her, which is one of the reasons why we're not covering the Karen Reed trial. So wonderful. We'll do that. And we'll do it. So before we waste too much time, we're going to do the music.
You're talking
that's
about
not
stuff
it.
that is
That's
not
the podcast. That's the podcast. Wrong one. This one. There we go. Runkle has been doing read recaps. I've thought about doing that. I don't want to step on other people's toes, and obviously there's a lot of coverage there. If I see a gap somewhere that I feel that I couldn't provide something that's not already out there, which honestly I don't think I can read, we might do that, but we'll see. Things can change. So, all right, tonight when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again in about 35 minutes or so. As the come back from lunch, because we have the closing from the accused, a pro se closing, in a capital case. It's going to be crazy. So hope you guys can join us for that. Thank you very much. We'll see you guys later. Bye.
The zombie apocalypse may be upon us.
Matthew, that's awesome. This is awesome. 18,000. You're going to catch her. You're going to get there.
When are we going to break for lunch, Judge?
Do give Matthew Harris Law a subscribe as well. It's well worth it. Great content. We'll see you guys after lunch.
This is not Burger King. People do not get to have it their way.
Is that correct?
He's the guy.